Okay, we'll go to Senate Bill 269. This is the establishing a process and grounds for a person to petition the court to vacate a conviction for obstructing a public place on the grounds that the person was homeless at the time of committing the offense. We have Democratic Party of Hawaii, GLBT Caucus. Michael. Good afternoon.
Good afternoon, Senator. Good afternoon, committee members. My name is Michael Galoya Jr. I am chair of the GLBT Caucus, and we are here in strong support of this measure. You have my written testimony. The only thing I would like to expand on that is when it comes to LGBT youth. As it stands now, there is no place for homeless youth to go when they are kicked out of their houses. And specifically, I'm referring to LGBT youth, since they represent about 40% of the homeless youth out there, when we represent 10% of the population in general. This is a huge disparity. So let me paint a picture for you. You are 15 years old, you are keeping a secret, and you're outed by a friend, supposed friend or a family member to your parents, and you are thrown out of your house by those wonderful people that were screaming, "Let the people vote." You have nowhere else to go. There's no shelter for you to go because it's against the law here in the Aloha State for a shelter to take you in under the age of 18. The only place left for you to go are the streets. And so therefore you are caught sleeping on the sidewalks. You are now have a criminal record. Coming from an HR background, you have now just given that person, a homeless person, that one extra barrier to be able to find a job, to be able to make something of themselves, to have them be able to be a full and productive member of society. And that's unfair. The laws need to be changed to ensure that we can have a homeless youth shelter. The O says there's about 110, 150 homeless youth in the urban core. Not to count the number of homeless youth that are couch surfing out there that were lucky enough to find a family member to take them in after being thrown out. So this bill does help that. We do hope you do move forward on it. We would like to see a bill that fixes the law that allows for homeless youth shelters to be able to take care of these youth, get them off the streets, and get them back into society and be able to become fruitful members.
Okay, thank you very much, Michael.
Thank you.
Hawaii Youth Services Network. Good afternoon.
Kathleen Johnson for Hawaii Service Network. Ms. Clark was unable to attend today and has requested that I read her testimony. Hawaii Service Network supports the intent of this bill. However, we are concerned about the impact of recently passed laws regarding use of sidewalks on runaway and homeless youth, as well as homeless adults and families on Oahu. Each year, youth outreach workers encounter more than 800 unaccompanied homeless youth. These are not living with their families, ages 12 to 21 on the streets of Oahu, primarily in Waikiki. We support the idea of vacating convictions for sitting or lying on the sidewalk or storing belongings there. A criminal record creates barriers for youth in obtaining employment, housing, or college financial aid. Homeless youth face enough challenges in getting off the streets without adding involvement of the criminal justice system. Hawaii Service Network is concerned, however, that this bill does not address some of the more immediate consequences of enforcement of the sidewalk laws. We have had reports recently from outreach workers about overzealous enforcement that has resulted in some youth losing identification and essential medications. Outreach workers have reported that when police encounter these youth sitting on Waikiki sidewalk, they enforce the sit-lie sidewalk ordinance and require the youth to leave the area. However, if the homeless youth's backpack or other possessions are on the sidewalk next to them and the youth is not physically holding them at the time the police officer approaches, they are told not to touch it and their possessions are confiscated. Homeless youth do not have the resources to pay the $200 fine in order to claim their belongings. The Honolulu Police Department has informed us that their practice is to photograph and inventory the possessions and then return the identification and medications to the individual. Runaway and homeless youth are afraid of involvement with law enforcement and may not wait while the police complete their inventory. They do not understand that they may be able to reclaim their ID and medications and think that they will be arrested if they do not leave the area immediately. Losing identification makes it difficult to help those youth enroll in school or obtain employment. Losing essential medication for conditions such as diabetes or epilepsy could be life-threatening. Hawaii Youth Service Network encourages the Hawaii Legislature to address these concerns. Thank you.
Thank you. Rob Hatch is in support, Imua Alliance. Chris?
Aloha, Chair Chun Oakland and committee members.
Aloha.
Thank you for hearing this bill. I'm Chris Caulfield, representing the Imua Alliance, speaking in strong support of this bill. You have our written testimony. I just want to highlight a few things that are in it. In recent years, Honolulu Mayor Kurt Caldwell and City Council members, over the strong objections of former City Council member Harimoto, have enacted several ordinances aimed at compassionately disrupting homelessness on Oahu. The most prominent of these ordinances are the recently enacted sit-lie bans, which were originally implemented in high commerce areas like Waikiki, but have been expanded to commercial properties throughout Oahu, including Windward and Leeward towns, and most recently on malls bordered by businesses. Now, city officials have argued that these measures are intended to preserve the legitimate, largely pedestrian use of public space necessary for commercial and recreational conduct. We believe those arguments are false for three reasons. First, the city ordinances amount to an unconstitutional, in our view, criminalization of the homeless. As many judges and legal experts around the country have repeatedly argued, these laws are selectively enforced against the homeless in the form of unannounced property raids, which constitute an unconstitutional violation of the Fourth Amendment's search and seizure protections. Following understandings of the term search and seizure that were articulated in the court case United States versus Jacobson in 1984, when law enforcement without notice raid a homeless encampment and usurp and often destroy, as was previously stated, houseless people's belongings, including basic government documents and identification, the city is quite frankly infringing on homeless people's civil rights. Second, these ordinances and sit-lie bans in particular are ineffective, serving neither to increase local economic activity or improve services for the homeless. Instead, these ordinances place significant cost upon local taxpayers. Every raid on a homeless encampment, for example, costs the city and county approximately $15,000, according to Mayor Caldwell himself. And similarly, burdensome expenses are borne by taxpayers by the storage and destruction of confiscated property and potential arrest, prosecution, and incarceration of violators. Third and finally, the aforementioned city laws do not and cannot incentivize housing unless an adequate supply of shelter space and affordable housing is already available. Currently, Hawaii has an adequate supply of neither for the more than 4,700 homeless in Honolulu and another 2,200 on the neighboring islands, totals that likely underreport reality given the understandable reluctance of large numbers of homeless people to participate in government studies. Criminalization will not cure homelessness, only housing will. That said, we encourage you to amend the beginning of page 1, line 9 of the bill to read obstructing or occupying a public place, thus ensuring that the measure applies to all obstruction violations, including park usage restrictions that prevent Hawaii's most vulnerable people from escaping the very streets to which they and their property have now been banned. We must ask ourselves as a society, as a committee, just as human beings, are poor people in need of a jail cell or a helping hand? We sincerely hope that you choose the latter. Thank you for the opportunity to testify in support of this bill.
Thank you, Chris. Pass.
Hate to go after that one. Thank you, Chris. My name is Catherine Xian, and I'm the Executive Director of the Pacific Alliance to Stop Slavery. I know two of you, three who have been here, know this issue very well. And so for that reason, I would like to just reiterate some points in my testimony. We are very much in support of the suggestion of the amendment that Chris had proposed. But also, there needs to be a remedy for houseless persons, for the selective enforcement brought forth by certain laws recently passed that criminalize them. As was stated, they do not help. They actually prolong homelessness. They make it exponentially difficult for social service providers to be be able to assist the houseless, especially if their medications and IDs are confiscated. For instance, you actually need ID for Housing First. So in order to get them the services that they need and deserve proactively and productively, these criminalization laws actually are a setback to that. I would like to also state that this was our last resort. As one of the co-authors of this bill, we don't really set out to contradict policy that's already been established. However, we have been here before. We've stated our case. We've produced studies of other sit-lie districts in the mainland that have proven that these types of laws do not work to the city council. There was overwhelming opposition against all of the ordinances that are now law, as former council member Breen Harimoto testified to and was witness to. Overwhelming opposition to these criminalization laws. At one point, the city council chair of the zoning committee actually said in public to the press that those bills, all of 5 of them that were being heard, would be deferred indefinitely. After a closed-door hearing with the mayor, that was retracted, and then the bills were reintroduced. So the democratic process wasn't really heeding, within the city council, wasn't really heeding the true essence of democracy and the many, many testifiers that came to plead their case, many of them also houseless persons. So this was our last resort. There needs to be a remedy. There currently isn't. And so this would actually afford them the rights and the freedom to be able to be unburdened from criminalization. Thank you very much.
Okay, thank you. Rainbow Family 808.
Thank you, Chair and members. Also, thank you for letting me speak the last time when I hadn't. I will get you testimony for that.
Thank you.
As president of Rainbow Family 808, it's hard for me to testify because I've never thrown my child out of the house. And neither one of them ever ran away. I wish sometimes they would, but they don't. And so it's hard for our family to understand any situation that if even Michael would run away at his advanced age, I would not sleep until I found out where he was. And if he was hurting, get him help and get our family help. And so I have a solution to all this. Instead of arresting the kids out on the street, let's arrest the parents who aren't being and abiding by their responsibility of parenthood. It doesn't just stop at 18 and it doesn't stop at 21. I realize that this bill has brighter ramifications for all of the people, but don't we want this land of aloha to take our brothers and sisters in? In 1981, when I came, I believed that motto, that we were the land of aloha, but I don't see that today. And so we'd make a lot of money. We'd have enough money to build drop-in centers and shelters for our children if we would arrest the parents and make them pay for these things. You don't have to add any more taxes on to our already burdened taxpayers. We would just make the parents accountable. Because every time it rains, I think of the kids that go to Yo. And I know they've got wet socks, and if they've been arrested, then they have to have a new backpack and all of it that's in it. And so Rainbow Family goes and we shuttle around and we take over what we can. Well, folks, it's not just Rainbow Family that's responsible for our kids. We're all responsible, but mainly make the parents pay. They need counseling at the very least. Thank you.
We have James Vivian Mateo in strong support. Kara in support. Lonnie Kwan in support. Patricia Blair in support. Shannon Rudolph in support. Sherry Pollock in support. Sylvia Pope Young in support. Thank you. Tadia Tadia Rice. In support, Terry Heed. In support, NASW. In support, Sina. Sina Klauser. In support, Lynn Onderkel. In support, Leslie Kiaha. In support, Mike Goloyu. In support. Oh, Daddy. Okay.
Yeah, he left. Good. No.
Go ahead.
I just wanted to say, Chair and members, that I do support this legislation and to beef it up even more. But one quick story again. Now, this had to do with the youth, but one of our friends that we worked with in Marriage Encounter, one day their son comes to our door. He'd been off to a seminary, but come back and they'd come out to him and they'd thrown him out. So he came to us, and we were able to take him in, and we were willing to watch over and help out at that time. Mm-hmm. And he was able to find some other friends to finally help him out and to keep going. So people are still being thrown out, and they still need help. And this measure will help them in one aspect. It won't help everything, but at least help out. And I think we need to decriminalize anything that has to do with the youth or adults in this case, so they can get work and jobs. Thank you.
Thank you. Amnesty International. Beatrice Cantelmo. Good afternoon.
Good afternoon. Thank you for having me here and for being here on Saturday. I won't repeat my testimony and a lot of what my colleagues have said, but I would like to highlight some points that I think it's very important when we think about why the Senate level, is stepping up, to create these bills, which are a huge mess that we were left with from our city last year with the SITLI ordinances that were passed, which in theory was supposed to be applied to each individual, regardless of whether they were homeless or not. However, from a civil rights standpoint, we need to also be realistic, and see really the selective enforcement of these bills and the real intention behind it. And we're really seeing it's really targeted towards the homeless. And so it is very unfair. It's discriminatory. When you have an entire system, from the judiciary to the law enforcement, and those who really are in support and have to enforce these bills, having to have the power and the discretion to figure out who they're going to punish, who are they going to select to, figure out who violated these bills and who didn't. And this is what's happening. Amnesty International has been very diligent in working with colleagues in Honolulu, but also, doing our own work and investigating what's really happening out there in the field. And we will attach the pictures, but I want to give a testimony of what I have witnessed in the Waikiki district, for example. And I think pictures speak more than like 1,000 words, really. And so you will be having that. But I will tell you the account of what I have encountered in several instances, but specifically in one instance where there were two women, senior female women. One was homeless and another one wasn't, having an indication that she was homeless. They were sitting about 10 feet apart from each other, different benches. And a Honolulu officer came towards the woman who was homeless and lying in this bench, a public bench, in plain daylight, and gave her a warning and said, "You need to move your belongings and get out of here and go into an area where the SITLI law is not enforced." Mm-hmm. And if you don't do that, you may be cited up to $1,000, go to court, have a criminal record, and may face jail time. This was a 79-year-old woman who didn't even have the strength, to do her whole journey to go to the beach which was something that, and I think most of us, have the freedom and really love to enjoy here in Hawaii. At the same token, the woman that was sitting next to her was not bothered by the police. And so I think we really need to pay attention, to what's really happening. And I think what your bill does is really bringing civil and human rights back to the state of Hawaii with regards to homelessness issues. You have an amazing opportunity through policymaking and legislation to really address homelessness, from its roots, and to really deal with housing issues as a human right issue. We have to stop criminalizing individuals, and I'm really in strong support of it. Thank you for the wonderful work you're doing.
Thank you. Okay, we have Robert Freed. He is also in support. Raina Whiting in support. Okay, Karen Murray. Yes, please come forward.
Hi, my name is Karen Murray, and I've been to many protests and many things in opposing all these inhumane laws, the sit and lie laws. My submitted testimony was very brief, and it goes like, I support this, at least this bill. I would like to see the sit and lie bills repealed. The crafters and supporters of the mean-spirited sit and lie bill should be convicted instead. It has no sense of humanity and reeks of oppression of apartheid. Are we heading toward concentration camps? The sit and lie bill should not have even existed, especially not in Hawaii. And the legislators passing these bills are killing aloha in the state. And it's an indicator of how colonized we truly are. But listening to the testimony on all the other bills today, it's like we're saying you have to wait 10 years for housing, on a list. There's 10,000 people on a list, so you have to wait 10 years to go to sleep. It's our society is not making any sense. It requires people to disappear, and which is impossible for adults as well as youth. So, I know a lot of this has been, the testimony has been focusing on youth, but adults can't disappear as much any more than youth can, and so. So to criminalize something like this in the first place was wrong, so I think that we should be able to vacate it, and hopefully in the future repeal the bills. Okay.
Thank you very much. We have any others? Okay, 4 others, and then we'll go to our last bill. Go ahead, Colin, go ahead. Oh, Michael. Okay, if you could be squishy, please. Sure. Can you? Michael.
No, I will ask the great 204 at the city council. You guys, I don't know what but I am highly opposed to any law. I'm opposed.
Can you speak to the bill, which this is vacating, not sit and lie? Can you speak to the bill itself, please?
Yeah, I'm supporting it. You can't come out of homelessness. You can't come out of homelessness. There are not in this economy when there's no more jobs. When this is the most expensive place in America to live on. But anyway, can this bill is wrong. You know, you need to create more housing options before you even consider this criminalization. Make a housing first. You know, a real housing first, not only 100 people. You know, homeless, and only what, 100 months ago. Until we get a real housing first program, I mean a real one. Yeah. How can we even think about this concept? Please, it's common sense. These are human beings who want, for whatever reason, need help. And we're going to complain. We're going to come here. I mean, this is almost a kid. A couple weeks ago, or last week, we commemorated the day of Martin Luther King Day, okay? There's a connection, okay? There's a connection. Yeah, you can do that. There you go.
Thank you, Michael. Okay, Colin.
Good afternoon, Madam Chair and members of the committee.
Good afternoon, Colin.
My name is Colin Kippen, and I'm the Hawaii Interagency Council on Homeless Chair, and I'm also the State Coordinator on Homelessness. And it is absolutely true that criminalizing the homeless does not work. It is not an effective strategy. It's a waste of resources. It clearly violates the constitutional and civil rights of human beings. It is not a cure. We know that. But what I want to do now is I want to shift my focus to the bill itself. Now, you know, for a lot of years I was a lawyer and a judge. I'm not that anymore. But in looking at the bill, I can tell you that there's some things you might want to think about, because were this bill to pass this august body and get to the governor's desk, he's going to be applying a different test. So here are some issues just off the top of my head sitting here that I thought about. Number one is, there's this question about the apportionment of power between the state and the counties that's at play here because of the mechanism of vacation that is now being put forward. So that needs to be checked out. The second is that it may violate the separation of powers between the judiciary and this legislative branch. And when you add that third body, which is now the counties, you can start to understand how it is that we need to figure out how that apportionment of power needs to be working. There are some specific things, some specific sections in the bill that I looked at as I was sitting there, and one of them is that it talks about being denied access to a homeless facility as one of the things that would need to be proven. There may be a good reason why someone might be denied access. For example, an assault may have been committed. A person may be convicted for the underlying assault and may not be invited to return to that facility. Same thing with services or programs. I mean, there may be reasons why a person is denied access, so I'd ask you to consider whether or not that's a crucial part of this bill. And then finally, in Section 2 at the end, it says, this act does not, and I'm leaving out two sections, does not affect proceedings that were begun before its effective date on pages 9 and 10. To me, that's an internal inconsistency. Here it is, you're literally trying to create a process that will literally reach back in time and vacate a previous conviction. So you need to think about what the appropriate language to be able to accomplish that might be in that section. Anyway, thank you very much for hearing this bill.
You mentioned page 8 and 9.
Oh, excuse me. It's 8 and 9 on page number 3. Section 2.
Line 8 and 9.
Yeah, lines 8 and 9. Excuse me, lines, it's actually 8, 9, and 10.
Would you be willing to work with the some of the community folks? That
Let's get a practicing lawyer here who's doing this. Let's call legal services. Let's get somebody doing this.
Okay.
I hung that.
Because
that shingle's put away. I don't do that anymore.
The other option was to move this out to the Judiciary Committee because they have more of that expertise.
Yes, I think that would be good.
Okay.
Yeah.
Thank you. All right. Let us go to Senate Bill 1014.
I think we had two more.
Oh, I'm sorry. Sir. I'm sorry. How many people are coming up?
There was 4 originally, and these are the last 2.
1, 2, 3, 4. I see hands. Okay. I'm just worried about the time. We're hoping to, but if you can be very succinct, I would appreciate it. Thank you.
Okay, mine's very brief. I'm Dave Atchison, resident of Chinatown. And
Dave
I was, and I have printed copies that I'll make available to everyone.
All right, thank you.
I was among those who testified against the sit-lie bills and did find the process dismaying that they were enacted. My testimony is this: I support Senate Bill 269. I feel it is important for the state to offer an avenue for vacating convictions under the sit-lie and related laws, which this is a little extra angle that I can add, which I feel are complex and ambiguous. For example, the convoluted sit-lie map for the Ala Moana zones is bounded by 25 different street segments. It's a very strange shape. It would be hard as, I tell my wife when I go out, and if I'm walking through there and want to sit down, I feel like I need to carry maps with me. And certainly, me having the ability to be at home on the internet and print those out, I have that. Houseless person does not. The sit-lie law for pedestrian malls makes it illegal to sit on planters, but many planters are clearly intended by their design as places to sit. I've not been able to resolve this ambiguity yet in the law, and I feel like these things leave those laws open to discriminatory enforcement, as we've heard in previous testimony. The laws themselves, passing this bill is an appropriate way to mitigate ongoing negative impacts that a conviction under the sit-lie laws would have on individuals' efforts to secure employment and otherwise improve their life situations. That's my testimony on that. On this same sheet, I also have testimony in support of 155 and 1014, so that will be available to you as well.
Okay, great. Thank you very much. Go ahead. Good afternoon.
Hi.
How are you?
Good afternoon. Good. How are you? Senators, Chun Oakland, senators. Sorry, different room. So used to the city. Yeah, it's my first time, so I never really submitted any testimony, but I can make you one later. Anyways.
Hello. So just introduce yourself.
My name is Tabitha Martin.
Speak to the bill itself, or speak in support or not support.
Yeah, this is in strong support of Bill 269. The youth, as Mr. Kippen had mentioned, that they need proof. I totally understand that, but there has been proof at one of the city council hearings. One of the testifiers she was a minor, and she had gone to a shelter to try and get into a shelter, but they denied her access because of her age. She didn't have ID, and there was no parental consent. So there's a real juggle between staying on the street or just seeking out help that probably isn't there.
I think we have to look at that, because I thought we passed a law several years ago that permitted the entry into a emergency shelter. So for those that may have more of the legal background, please identify what part of the HRS is still not working so that we can address that concern.
Because not
young
just
people should be able to come in.
But there's been a lot of kids in Kakako itself, maybe about 5 off the top of my head I can think of, that had the similar problems because their parents probably threw them out, or they're running away from them, from home or whatever. Whatever the reason may be, they're on the streets. And it's still a danger for them too, especially at their age. They just had reached adolescence, and they're going through some major changes in their life, and all they really want is to fit in, especially when they go to school. They don't want to be ridiculed for being homeless or out on the street and be some street rat. You know, it's regardless, because once you get a criminal record for being on the streets or anything related to being on the streets, it stays with you for a long time, you know. And I mean, you could be successful in your future, and they look back on your record and they see that on your, you know, on your record, your background, it's not something to be proud of.
Thank you, Tabitha.
Thank you.
We appreciate it. Okay, sir, David.
I'll save my comment for the next bill, but I'm totally in support of this.
Okay, thank you. And Annabelle?
I'm in support. I will actually be at judiciary hearing for that. Thank you. I apologize. I thought I had testimony.
No, not at all. If you have some better solution to what I think Colin is raising, if we want the measure to be successful and go through this up to the governor, not be vetoed, we do need to be cognizant of those concerns. So anyone with that legal background to help, I'd appreciate it. The next is Senate Bill 1014.